Your autonomic nervous system overrides conscious muscle control in milliseconds to prevent fatal physical errors. In generational wealth, a dormant 1980s property addendum acts as this exact biological failsafe, instantly paralyzing a patriarch's LLC liquidation. This is the story of my family's commercial real estate enterprise, and the decade-long restructuring designed to quietly erase my name from it. Names and specific municipal identifiers have been changed for privacy, but the legal mechanics remain exactly as they unfolded. By the end of this case study, you will understand why the most airtight corporate restructuring can be entirely undone by a single, forgotten paragraph drafted 40 years prior. My father, Elias, built a substantial portfolio of mixed-use commercial properties in the Pacific Northwest starting in the late 1970s. The foundation of this wealth was not just the physical buildings, but the original 1983 family trust that held the underlying land titles. I am the youngest of 3 children. My older brothers, Marcus and David, were integrated into the daily operations of the business early on. I pursued a career in structural engineering, remaining a passive beneficiary of the trust. For the first 30 years, this arrangement functioned without friction. The trust distributed quarterly dividends. The properties were maintained. The legal architecture remained static. The shift began in 2012. It did not start with a confrontation or a formal meeting. It started with subtle changes in the annual tax documentation. In family enterprise law, quietly restructuring assets to exclude an heir leaves a very specific, undeniable paper trail. My father began migrating individual properties out of the 1983 trust and into a newly formed entity called Cascadia Management LLC. The stated purpose was liability protection and streamlined management. On the surface, it was a standard modernization of a legacy portfolio. But the mechanism of transfer was where the exclusion occurred. The properties were transferred via quitclaim deeds. The grantee was Cascadia Management LLC. However, the membership units of the LLC were not distributed equally among the 3 trust beneficiaries. Marcus and David received Class A voting shares, representing 60% of the equity. I was issued Class B non-voting shares, representing 20%. The remaining 20% was retained by my father. Over the next decade, this structure was used to systematically dilute my economic interest. When Cascadia Management took on debt to acquire new properties, the capital calls were structured in a way that required cash contributions. As a passive beneficiary without access to the company's operational cash flow, my Class B shares were progressively diluted down to just 4% by 2021. I want to pause here and note a specific anomaly in the 2014 county recorder filings. When the first major commercial plaza was transferred into the LLC, the title company required a secondary sign-off on the deed. We will come back to this in a moment, as this specific 2014 filing is the linchpin of the entire case. For years, I monitored these changes through public records and my annual Schedule K-1 tax forms. The realization of my exclusion did not arrive as an emotional shock, but as a mathematical certainty. The generational wealth was being consolidated into an entity where I held no voting power and a shrinking economic stake. In early 2022, the final phase of the restructuring was initiated. My father, now in his late 70s, decided to liquidate Cascadia Management LLC. He engaged a mid-market private equity firm to acquire the entire portfolio. The letter of intent was signed in March 2022, valuing the LLC at $42 million. Because I held a mere 4% of non-voting Class B shares, my payout would have been approximately $1.6 million, minus the aggressive management fees my brothers had retroactively applied to the LLC's operating agreement. The original 1983 trust, which would have guaranteed me a full third of the estate's baseline value, was effectively being bypassed. Before we examine the due diligence phase that unraveled this transaction, I want to ask you a question. Looking at these 3 structural moves, the 2014 quitclaim deed anomaly, the 2018 operating agreement amendment that created the Class B shares, and the 2021 debt-funded capital call, which red flag would you have caught first? Comment 1, 2, or 3 below. Understanding how these mechanisms interact is crucial to seeing how the failsafe was eventually triggered. The private equity firm initiated their standard due diligence process in April 2022. This involved a comprehensive title search on all 12 commercial parcels held by Cascadia Management LLC. Their legal team was looking for liens, encumbrances, environmental hazards, and chain of title defects. What they found was not a defect in the modern LLC structure, but a dormant covenant attached to the underlying land itself. When the original 1983 trust was drafted, my grandfather's attorney included a specific addendum to the foundational property deeds. It was a covenant running with the land. It stated that any transfer of the underlying parcels, whether direct or via a change in controlling interest of a holding entity, triggered an automatic right of first refusal for the original grantor's descendants. This right of first refusal was not just a standard matching clause. It was priced at the original 1983 assessed value, adjusted only for the Consumer Price Index. Furthermore, the addendum explicitly stated that this right could not be waived, amended, or superseded by any subsequent corporate restructuring, LLC formation, or operating agreement. My father and his corporate attorneys had focused entirely on the modern LLC operating agreements. They had forgotten the biological failsafe buried in the 1983 property deed. The land itself remembered the original terms. In May 2022, the title insurance company issued a preliminary title report for the private equity firm. Schedule B of the report listed the 1983 right of first refusal as a primary encumbrance. The title company refused to insure the transfer unless the right was formally waived by all original descendants or exercised. The private equity firm's legal counsel immediately halted the transaction. They sent a formal notice to Cascadia Management LLC, demanding clarification on the encumbrance. This is when my father's attorneys realized the structural flaw. To clear the title and proceed with the $42 million sale, my father needed my signature to waive the right of first refusal. For the first time in a decade, my legal consent was absolutely required. The confrontation was not a loud, emotional argument. It was a series of highly formalized legal correspondence. My father's legal team sent a draft waiver, offering me a $2 million settlement to sign away my rights. It was a slight premium over my diluted 4% share, designed to make the waiver seem like a generous concession. I did not respond to the settlement offer. Instead, I retained a specialist in commercial real estate trusts. We reviewed the 1983 addendum, the 2014 quitclaim deed anomaly I mentioned earlier, and the private equity firm's letter of intent. The 2014 filing was critical. When the first property was moved into the LLC, the title company at that time had flagged the 1983 addendum. My father had signed an affidavit in 2014 stating that the transfer to the LLC did not constitute a change in controlling interest because the trust remained the ultimate beneficiary. That 2014 affidavit legally bound the LLC to the original trust's distribution rules. Armed with the 2014 affidavit and the 1983 addendum, my attorney filed a formal notice of exercise of the right of first refusal on my behalf. We did not actually have the capital to purchase the $42 million portfolio at the 1983 inflation-adjusted price, which calculated out to roughly $18 million. But we didn't need to. The legal mechanism of the addendum dictated that upon the exercise of the right, the proposed third-party sale was automatically nullified. The assets could not be sold to the private equity firm. Furthermore, because the LLC had attempted to bypass the right of first refusal, the addendum contained a penalty clause. The LLC structure was deemed in breach of the foundational covenant, triggering an automatic reversion of the properties back into the original 1983 trust. The biological failsafe had engaged. The private equity firm, faced with a clouded title and a pending legal reversion, withdrew their letter of intent in June 2022. The $42 million liquidation was dead. Over the next 6 months, the legal reality settled in. The county recorder processed the reversion documents. The 12 commercial parcels were transferred out of Cascadia Management LLC and back into the 1983 Family Trust. My brother's Class A voting shares and my diluted Class B shares were rendered void, as the LLC was effectively stripped of its underlying assets. The portfolio was back to its original state. I was once again a full, one-third beneficiary of the trust, exactly as my grandfather had structured it 40 years ago. My father's attempt to quietly restructure the generational wealth had failed, not because of a dramatic courtroom battle, but because of a fundamental misunderstanding of legal memory. He believed that modern corporate structures could overwrite foundational property law. He was wrong. The aftermath was quiet. There were no apologies, no admissions of wrongdoing. The relationship with my father and brothers remained strictly professional, mediated entirely through the trust's independent fiduciary. The quarterly dividends resumed, calculated on the full one-third distribution. The final insight I promised at the beginning of this case study is this: legal architecture has a memory that outlasts human intent. In the pursuit of optimizing wealth, controlling shareholders often view legacy documents as obsolete hurdles to be engineered around. But property law is built on the concept of perpetuity. A covenant running with the land does not age, and it does not forget. When you attempt to quietly exclude an heir through complex corporate restructuring, you are not just fighting the current beneficiaries. You are fighting the original architects of the estate. And in the hierarchy of law, the foundation almost always outlasts the renovation. Trust is a fragile human construct, but a properly drafted property addendum is a permanent mechanical one. In the end, the paper trail doesn't just reveal the truth. It enforces it.